Welcome to the deep dive. We're kicking off an educational journey into the Manual of Patent Examining Procedure,
Yeah,
the MPEP.
that's right.
Think of this as your shortcut to understanding the essentials of patent examination one section at a time.
Exactly. And this time we're jumping into Chapter 2100, Patentability.
Okay,
Specifically, we're really zeroing in on Section 2158.
it's 158, got it.
Yeah, our focus today is AIA 35 U.S.C. 103. That's really the heart of the non-obviousness requirement under the America Invents Act's first-inventor-to-file system.
Okay, non-obviousness under the AIA sounds pretty critical. So, in a nutshell, what's the key thing here? What are we really trying to understand with this section?
Well, the core mission really is to grasp how the AIA fundamentally changed the way we figure out if an invention is obvious and, therefore not patentable.
Right.
This particular section of the MPEP, 2158, it just lays out the specifics of that really significant shift.
Okay, let's dive right into that shift then. What is the core principle of this AIA 35 U.S.C. 103?
Essentially, AIA 103 says an invention can't be patented if the differences between it and, well, the existing technology, what we call prior art, if those differences would have been obvious to someone skilled in that specific field before the invention's effective filing date.
Before its effective filing date. Oh, okay, that sounds like a notable detail. How is that different from, the old way?
That's a really crucial change. Before the AIA, the standard for obviousness was generally tied to the date the invention was actually made,
Oh, okay.
unless there was maybe evidence proving otherwise. The AIA moved that benchmark. Now it anchors the whole prior art assessment solely to the effective filing date of the application. And this, it seems like a small change, but it really impacts your strategy. It means you've got to be super aware of any public disclosures before you file.
Right.
Because those are now the main things used to judge obviousness.
Right.
Getting that filing date secured early is, well, more critical than ever.
So it sounds like this simplifies the timeline, maybe, for looking at what's already out there?
Precisely. Yeah, it creates a much more straightforward, consistent point in time for evaluating the existing knowledge in the field.
Now, the MPEP mentions some terminology nuances. Is the actual wording different in the law under the AIA?
Yes, there is a subtle shift in the language, but it's important. The pre-AIA version of 103 talked about the obviousness of the subject matter sought to be patented.
Okay.
The AIA version, however, refers to the obviousness of the claimed invention.
The claimed invention. Has this slight wording change had a big impact on how courts see things?
What's fascinating here is that even with that change, courts, and notably the Supreme Court in Graham v. John Deere,
Right.
they've pretty much interpreted these phrases as essentially the same thing. The core analysis still really focuses on the specific language in the patent claims. That defines the invention's boundaries.
I see.
So, yeah, the words are different, but the practical way we analyze claims for obviousness hasn't fundamentally changed just because of that specific wording tweak.
Okay, so the core principle and the wording shift are important. Now, the MPEP also mentions some significant omissions from AIA 103. What key parts of the old law are just gone now from the obviousness analysis?
Okay, one big omission is the biotechnological safe harbor that used to be in pre-AIA 103B. And this provision could, under certain conditions, basically say specific biotech processes were non-obvious.
Why was that removed? Did something change legally?
Well, if you look at the bigger picture, later court decisions, especially cases like Inri Okiai and Inri Brouwer.
Mark cases.
Exactly. They clarified how obviousness applies to certain biotech processes, and they essentially addressed the issues the safe harbor was meant to cover anyway.
Okay.
So the specific rule in the law became, well, less critical because of those court precedents.
That makes sense. The courts kind of caught up or clarified it. What else was taken out of AIA 103?
Another key change is getting rid of the pre-AIA 103C exception. This dealt with commonly owned subject matter.
Right, I remember that.
Yeah, this exception could stop certain prior art from being used against an invention if it was owned by the same company or person when the invention was made.
So how are those situations handled now? Overlapping inventions, same owner.
This is where it gets really interesting, actually. These issues, things like joint research agreements or common ownership, they're now handled in different parts of the AIA.
Okay.
Specifically, you'll find them in 35 U.S.C. 102B 2C and also 102C.
And is there a key difference in when that common ownership needs to be in place?
Absolutely. The critical timing change is this. The common ownership or the obligation to assign the invention, It must exist by the effective filing date of the invention being claimed.
Not the invention date.
Exactly. Not the date the invention was conceived or made, like it was under the old 103C. Again, it all circles back to that filing date.
Okay, to really sort of nail down this idea about the timing of common ownership, could you walk us through an example, a hypothetical?
Sure, sure. Let's imagine two researchers working under a formal joint research agreement, a JRA. They independently come up with related inventions. Now, one of these inventions gets described in a paper that's published, but it's published after the effective filing date for the patent application covering the second invention.
Right.
Now, technically, under AIA 102 or A1, that published paper counts as prior art.
Makes sense.
However, because there was a properly documented JRA in place before that crucial effective filing date,
Ah,
the exception in 102B2 would likely kick in, and that would stop the paper from being used to reject the second invention's claims based on obviousness.
okay, I see. So that documented agreement, by the filing date, that's the key to using that exception. What if that agreement wasn't there or wasn't documented properly by the filing date?
Right, good question. In that scenario, if the publication otherwise meets the definition of prior art under AIA 102,
Then it counts.
then yes, it could be used by a patent examiner to support an obviousness rejection under AIA 103. Without a qualifying exception linked to that filing date, it's fair game as relevant prior art.
Wow, that really underscores the importance strategically of getting those agreements locked down and documented early on.
Absolutely.
So what does all this mean for the patent examiner who's actually looking at these applications? How does this affect their process?
Yeah, that brings up an important point about the examiner's workflow. The MPEP is really clear on this.
Okay.
Examiners have to first determine if something even qualifies as prior art under AIA 102 before they can use it as a basis for an obviousness rejection under AIA 103.
Oh, it's sequential.
Exactly. It's a two-step process,
Okay.
essentially. First, is this thing prior art according to AIA 102 rules? Second, if yes, would the invention have been obvious considering the prior art based on AIA 103?
That makes perfect sense. You can't build an obviousness case on something that isn't even technically prior art yet.
Precisely.
Okay, one last point from this MPEP section that stood out was about the role of non-enabling prior art. What does that mean when we're talking obviousness?
Right? This is a subtle but really critical distinction. For a prior art, reference to block a patent claim based on anticipation.
Which means the reference shows the exact same invention.
Okay,
Right.
every single element. For that, the reference has to be enabling. It needs to provide enough detail for someone skilled in the field to actually make and use the invention.
Like a recipe.
Yeah, think of it like a recipe. If a prior recipe is missing a key ingredient or a crucial step so you can't actually make the dish, well, it's non-enabling for anticipation.
But the rules are different for obviousness.
They are. A reference that doesn't fully enable the invention all by itself can still be used as part of an obviousness rejection,
Okay.
even if it doesn't teach someone how to make or use the whole claimed invention. If it teaches relevant concepts or ideas or maybe components to someone skilled in the art.
Can be combined.
Yes, it can be combined with other pieces of prior art to argue that the overall claimed invention would have been obvious. And this isn't just a theory, it's backed up by case law, like Symbol Technologies v. Opticon and Beckman Instruments v. LKB Productor AB.
So using the recipe analogy, even if that old recipe is incomplete, if it still teaches a really important technique or uses a unique ingredient that, when you combine it with other known recipes, makes your new dish seem obvious.
Then that non-enabling recipe still counts towards obviousness. That's the idea.
So even if a prior art reference isn't a complete blueprint, it can still add pieces to the puzzle for an obviousness finding.
Precisely. It's about the collective knowledge, the teachings found within the whole body of prior art, even if no single reference perfectly spells out the claimed invention in an enabling way.
Well, this has been a really clear and insightful look at AIA 35 U.S.C. 103, guided by MPEP Section 2158. To kind of wrap it up, can you give us a quick rundown of the most important takeaways?
Sure thing. The key shifts from pre-AIA to AIA 103 really center on that effective filing date being the main point of reference for prior art.
Right. That date is key.
Definitely. And we've seen big changes in how commonly owned inventions and research agreements are handled. They now fall under those AIA 102 exceptions, not the old 103C.
Okay.
And finally, it's just crucial for you to remember that even prior art that doesn't fully enable an invention can still be very relevant when assessing obviousness.
It certainly highlights how the AIA has reshaped the patentability landscape and, the whole examination process. Thanks so much for walking us through this today.
My pleasure. Glad to do it.
And we also want to give a special thanks to Mike Shepard. He's the creative director who organized this entire educational series on the MPEP.
Yeah, thanks, Mike.
He's making this important information much more accessible for you. Now, before we officially sign off, just our usual quick reminder and disclaimer. This summary was put together using AI tools, things like ChatGPT and Notebook LM, and, well, it might contain errors or omissions.
It's possible.
It's really provided for general educational and informational purposes only. It's definitely not legal advice or a replacement for formal instruction.
That's essential advice. Always check the source.
Exactly. For the authoritative guidance, please consult the official MPEP itself, talk to a qualified instructor, or get advice from a registered patent practitioner.
Good advice.
So as you think about these changes to the obviousness standard, maybe consider how this AIA focus on the effective filing date might influence your approach, how you time invention disclosures, and just the strategic importance of filing those patent applications early. It seems like a small detail, but it can have really big real-world consequences in the patent world.
It really can.
Thanks again for joining us for this deep dive, and we look forward to continuing our exploration of the MPEP with you next time.